So what are the things we want to know for sure when we're drafting a New Jersey will, or really any will, and I'll digress where appropriate. First, who can make a will in New Jersey? The law is, if you're over 18 and you are of sound mind, then you're capable of making a will. There are certain formalities that are required whenever you execute a will in New Jersey. It must be in writing. The witnesses, generally they require 2 witnesses. If you do a will that is in handwriting, then so long as the material portions of it and a signature are done in your handwriting, then unlike in other states, it's a valid will. New Jersey does not accept or allow cupative wills or non-cupative wills. They're verbal or oral wills. Let me talk about one of the estates we had some time ago. This was an individual, bless you, this was an individual who decided that he knew better. He hand-wrote his entire will. He divided it up into, 63 shares. He had other beneficiaries outside of the will that were for the IRA and for other beneficiary bequests. And he put in, it was probably like a 5-page discussion of his funeral instructions. And then he passed away. He didn't have it witnessed. He didn't do any of those things. What does New Jersey do about that? Let's talk about how New Jersey court system works generally. In New York, the procedure is you submit a petition with a bunch of additional forms, you file them with the surrogate, and the will is approved after everyone in the world is given notice. But in New Jersey, the situation is the opposite. There is a clerk's office where the surrogate, who's a non-judicial individual, has the authority to approve the admission of a will to probate without going through a formal court proceeding. But it requires that the will, on its face, accommodate the requirements of New Jersey's laws. So it has to have signatures, it has to be, the person has to have acknowledged that they signed it, they have to have witnesses, all those things, that has to be in writing. If any of those things are not met, then New Jersey requires that the surrogate, the informal process, is not available, and the surrogate switches hats and becomes the clerk of the Superior Court for the purpose of probating wills in a formal proceeding, in solemn form, they call it in New Jersey. So you no longer can go informally in a cheap, quick, less than 15-day process. And now you have to go through a court process, which is expensive, complicated, started by an order to show cause. It's a whole different project. So the purpose of having, the advantage of having a will that matches New Jersey's requirements is that it makes the entire probate process quick and easy. In fact, years ago, I had a client who lived in Florida, and he was coming back to New Jersey, and he would always send me articles from the Wall Street Journal. They were like little tests. He was 93 years old. He had nothing else to do. So he'd send me these little articles saying, I just read this article. Do I have this? Do I need this? And they were the kinds of articles where in other states, there's a big push to do, as the primary estate planning document, a revocable trust, an agreement where the person sets forth their estate plan in a document that exists now, is revocable, in other words, changeable, and it is intended to avoid the probate process, because in most states, certainly not New Jersey, the probate process is expensive and time-consuming. At that time, I said to him, oh no, nobody's doing doing revocable trusts in New Jersey, because New Jersey is a cheap and quick probate state. I don't even need to go with you. You take the will, you take the death certificate, and I'm speaking to the executor now, the will and the death certificate, and you walk into the surrogate's office, and it's just a clerk's office, and they say, do you promise to do what it says? Yep. Is it more than 10 days after the person died? Yep. Do you have photo ID? Yep. Well, then the will's admitted to probate. And within 3 to 5 days, as long as it's 10 days or more after the decedent died, letters testamentary will be issued, which is the certificate giving authority for the person named as executor to act. And the will's admitted to probate. And we're off.